When they said underwear and she admitted to underwear, I don't think they ever found it in her, excuse my, like her panties. But some people, when they say underwear, they mean bra and panties or underwear. And some people, it's like your panties. So when she said underwear, I think she was referring to her bra, not, I don't think anyone is saying that they found it in her panties area.
Well, I'm reading what I'm reading from the police report is that they're saying bra and underwear, and they said both located. 707 State of Texas versus Regina Weaver. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense.
Eddie Brovinick for Miss Weaver.
And are you Miss Weaver?
Yes, ma'am.
I'm sorry, you're going to need to put your purse down on one of the tables. Counsel, have you received all the discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Ms. Weaver, did you review the document entitled Application for Community Supervision or Deferred Adjudication with your attorney?
Yes,
Did you understand it and sign it?
yes.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Judge, we're waiving the repeat offender enhancement allegation. And in addition, Judge, just to put on the record, defense did ask about possible surveillance video from inside the Bexar County Jail on this case. I had emailed out to the detective, forwarded on my request to someone at the Bexar County Jail. So far, we haven't gotten word of it, but I did inform the defense about that. But we decided to again make this offer, reach this agreement despite that.
All right, and defense, do you wish to proceed without that discovery if it exists?
We do. I went over the issue thoroughly with Miss Weaver, and honestly, I got her slightly better deal because of the issues with the discovery. And I went over it and said, look, if you truly didn't do this, we should wait for the video. In spite of that advice, Miss Weaver chose to go forward. So it did help her, although there was that out-ascending discovery issue. So I went over each and every issue on the case, and she was satisfied that she still wanted to go forward.
All right, and state, other than waiving the repeat offender enhancement allegation, are you proceeding on the indictment as presented?
Yes, Judge.
Any objection to the state's waiver?
No,
All right, Ms. Weaver, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged by indictment with possession of a controlled substance, penalty group 1, 4 grams to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? You need to speak up.
Yes, ma'am.
Did you understand by entering this plea you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
she has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Weaver will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $500 fine. State recommends deferred adjudication. They're taking in consideration 2024 CR 2832, and they're asking for a referral to felony drug court. Did you understand that should be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
There have not.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years, that there be a TAP evaluation and 120 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No.
State any evidence.
State offer states given one and all attachments.
No objections.
All right, did you review, state you may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
If the court would allow us, yes.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right. So I have a few questions. So do you have any children?
Yes, ma'am.
What are their ages?
21, 14, 9, 8, and 7.
All right. And where are they? Who do they live with?
My 14-year-old lives with me. My 21-year-old is out of the house, and I share custody with the younger 3.
If you're drug tested today, what are the results going to be? And you're going to get drug tested. Here's the thing. You need to be honest with me.
Yes, ma'am. The medication that I take, I don't know how it comes up on the test, but I do take medications
For what?
for anxiety and depression.
I'm sorry, what?
Anxiety and depression.
And so
And
what were you doing with meth? I don't know how they missed that at the jail, but they say it was found when they were doing cell checks at the jail, and that you were attempting to flush something down the toilet.
I had just come back from the hospital having an x-ray done, and it was found in the cell with me. There was nothing found on me. It was in the cell, and I'm not too sure.
Well, I think what her real question is, you've used meth, right?
Yes.
All right.
Because it's saying that it was found inside her bra.
Yes, I think it stated that it was being flushed down the toilet and that it was found inside a bra. I think she's I don't know. I mean, she may say differently. I think her concern is the drugs, right? Using drugs. And she wants to tell you to tell her if.
Yes. Yeah, that's what I'm trying to
Yes.
understand, because what I'm reading, the stipulations that you stipulated to, it says, detention staff were conducting cell checks and they noticed you attempting to flush something down the toilet. Detention guard Garcia then requested for additional help in restraining you and retrieving E2. I was then advised the detention staff then conducted a strip search of everyone in the cell and located E1 inside AP1's bra. I was then advised that AP told the detention guards that E2 was located inside her underwear. So they're saying that you told them it was located in your underwear, both locations which would constitute a strip search. So they're saying they found it in the underwear and the bra.
So
And then
Judge,
what?
if I may, I'm sorry, and I had trouble with this first. When they said underwear and she admitted to underwear,
Mhm.
I don't think they ever found it in her, her panties. But some people, when they say underwear, they mean bra and panties or underwear. And some people, it's like your panties. So when she said underwear, I think she was referring to her bra, I don't think anyone is saying that they found it in her panties area.
Well, I'm reading what I'm reading from the police report is that they're saying bra and underwear, and they said both locations.
Yeah, so Judge, I literally, I don't think it says they found it in both. I think she says I admitted it was underwear, and I don't mean to make a mountain on a molehill, but I think when she says she admitted it was in her underwear, she means she's admitting that it's in her bra. And I don't think that the state would say, nor does anyone saying that.
So here's the thing, that what I'm reading in the report, whether it's underwear or bra, it's on her,
Yes,
and it's not something from the hospital because they're saying it was in clear bagging. Unless the hospital has started putting their medications in clear baggies.
No, ma'am. It was in a wrapper for a sanitary napkin.
Okay.
And it was in the cell with me. I do have an issue with, I used previously. But since then I've stopped using and attempted to get things back on track in my life.
Okay. So are you employed?
No, ma'am, not currently. I was on full house arrest.
All right. So have you ever had employment?
Yes.
Doing what?
I was a server for a restaurant for a while, and then for the past, I want to say, a year or so, I haven't.
Speak up, ma'am.
Yes, for the past year or so, I haven't been employed just because I was trying to. I actually lived in Beeville, and then I moved back here to San Antonio. While I was moving, was when this incident occurred.
All right. Who lives with you with your children?
Myself and my grandfather.
All right. This is what the court is going to do. The court is going to sentence you to 4 years deferred adjudication. There's going to be a referral to felony drug court. She can do that out of custody. Do not miss that appointment. Do you understand?
Yes, ma'am.
And there'll be a TAP evaluation out of custody. Follow recommendations. And you need to let felony drug court know about your drug history and your drug issues. You understand?
Yes, ma'am.
There's a $500 fine that will be probated. I'm going to order the UA hotline until further notice. And we're going to have you do a drug test today. No later than 3 p.m.
Yes, ma'am.
And they'll give you the location.
Yes, ma'am.
There's to be regular reporting by Zoom or in person. Proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There's going to be 90 sober meetings in 90 days. Field visits 1 time per month until in treatment. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once you complete the parenting classes, the community service hours will be deemed satisfied. There's to be no unsupervised contact with minors. Once you've started parenting classes, your counsel can approach me about that, and I'll consider changing that. Take in consideration 2024 CR 2832.
Chief, I'm sorry, may I ask a question?
Yes.
I'm sorry, when you say no unsupervised contact, you mean minors besides her children? Because
Children, period. So she says she lives with her grandfather, so I'm assuming her grandfather is there.
but I think her testimony is their 14-year-old is currently with her.
Yes.
I don't know what we do with a 14-year-old.
But no, she said that she was, I said, who's living with you and your children? And she said the grandfather.
Yeah.
So my concern, if the court says no unsupervised contact, so the grandfather is sufficient to satisfy. All right. I'm just making sure I don't set her up for failure.
All right, thank you.
Thank you.
Take in consideration 2024 CR 2832. And there's to be restitution, if any, to the Bexar County Laboratory for drug testing. Probation, is there anything else she needs? Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
We can go off the record, and this court, to be successful on probation, communication is key. If you have an issue, let probation know. If you feel as though they're not addressing it, you can always come back to the court. Do you understand?
Yes, ma'am.
All right, good luck to you. Court is calling 2023 CR 8806, State of Texas versus Christopher Scott Jones. Can I have parties announced for the record for the state?
Zach Dunn for the state, Your Honor.
Defense?
David McLean for the defense.
And are you Christopher Scott Jones?
Sir.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Christopher Scott Jones who was placed on deferred adjudication in 2023 CR 8806 for the offense of assault, family second offense on November 28, 2023 for a period of 6 years? Is that you?
Yes, ma'am.
State?
Your Honor, on or about the 21st day of March, 2024, in Bear County, Texas, the defendant, Christopher Scott Jones, did then and there contact Scarlett Jones in person in violation of condition number 19.
How do you plead to that? True or not true?
True.
And then, Your Honor, the state will waive and abandon the others.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 19, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 19? Court will find violation of condition number 19 true. The court will let both parties know. The court has received these documents in the court's file. I have not read them because I don't read anything until both parties have had a chance to view them and have any objections to them.
Absolutely, Your Honor.
So have you all both had a chance to review the documents that are sent to the court's file?
I have not, Your Honor.
Those are the ones from last year.
Okay, we were what we talked about last time.
That's exactly right. Yeah, there's nothing new. Those are from, nothing from the past like week or two, correct, Your Honor? Those
No.
No, so yes, I believe counsel and I have reviewed them in depth, all of them together.
All right, and would you like the court to read these, counsel, or do you have objections?
Essentially, Judge, they're hearsay, but I know the court can consider that.
Well, I mean, if you all have objections to it, then I won't read them. They are hearsay.
I object. Judge.
All right. All right, so if the witnesses are not here for the court to read those, then the objection will be sustained.
Thank you.
All right. So is there a proposed agreement?
There is, Judge.
And what is the proposed agreement?
The proposed agreement, Your Honor, is for amending conditions for zero tolerance, house arrest for 30 days, GPS for the remainder of his term, extension for 1 year, and enroll in VIP within 15 days of release.
All right, and who is Scarlett Jones, and why is he contacting Scarlett Jones?
I can get a relationship chart for you, Your Honor. It's a little bit complicated within the.
Everyone, please whisper.
I can get you an answer, Judge. It's in the file. We literally had to draw this out across a couple of cases, Your Honor. Off the top of my head, I don't know, but I can get that information for you in the state's file.
All right, is it Scarlett Jones or Sydney Jones?
It's, I believe, Sydney Scarlett Jones.
Okay,
Same person, Judge.
all right, same person. So I ordered,
No, Scarlett Jones is my wife in the movie.
Okay. Scarlett Jones is Mr. Jones' wife.
all right, and who is Sydney Jones?
My daughter.
All right, and Scarlett Jones, okay. The court ordered no contact with Scarlett Jones and Sydney Jones.
And Your Honor, may I ask a quick question? The council may know.
Yes.
From a movie, who is that?
No, Scarlett Jones is the person he pled true to the number 19 violation,
Yes,
and I ordered no contact with that person.
understood.
So I want to know why my no contact orders are being violated. That's where we are. Does anyone want to address that?
Your Honor, this is unfortunately not an uncommon situation that happens when you've got parties that are getting divorced, you have new paramours involved.
So was this contact made at a courthouse?
It wasn't made at a courthouse. It was not, Judge. From what my understanding is that he had gone by, and he is struggling mentally to try to let go of what this relationship was. He misses his kids. He misses his wife. Unfortunately, she's moved on. What I can tell the court is that it appears that there was an application for a protective order filed, correct? My client has agreed to the entry of that protective order. It is a 5-year protective order.
But how old is he? How old is your client?
How old is my client?
Yeah.
I would say probably like 40, 45.
All right, so I don't understand what he doesn't understand, that the court ordered a no contact order with Scarlett Jones. I mean, I know you all have your proposed agreement, but I don't know why I should follow this. I ordered no contact with Scarlett Jones. All of this nonsense about people not being able to let go. You can cry, when nobody's around, ask the gods, why am I not with this person? But I told him he couldn't be with her anymore.
Judge, I understand that, and I fully respect your position. Sometimes emotions get better at people, and I'm not saying that's an excuse, but I think that's the reality of what happened. Nobody was harmed. Nobody was, I don't believe in, nothing happened from the contact. I'm trying to get this guy back on track.
Yeah, but this is what I want you to understand where I'm coming from. I ordered no contact with Scarlett Jones. I ordered no contact with Sydney Jones. This is an assault family second offense, and we probably wouldn't be here, and maybe you would still be in a relationship with them if we were not here for an assault family second offense. So I don't know why people tend to cause problems in relationships and then are shocked when somebody moves on and they don't want you anymore. So I don't know why I should follow your agreement when the main thing the court ordered was no contact. And this is a family violence case. And people don't want people showing up to their door because they've moved on and they don't want you anymore. I don't understand why people don't understand when people don't want to be with you anymore. It's like, I'm over, I'm done. I don't want you anymore. Why can't people internalize that?
I think he has. I think this time in jail has helped him do that. And Judge, if I had a reason for you to follow this, it would be to provide him the assistance that he needs to try and reform himself. I think the battery intervention program alone will do wonders for him. It will open his eyes as to what's going on here. And I also think that, like we said, he's been in jail for about 60 days now. He's going to have another 30 on house arrest. He's going to be on GPS. We can not only monitor him and protect the family, but he's got a protective order in place. I've already explained that to him, and this is for the record. I've explained to him that protective orders have teeth. And that if he violates that, it's not just an MTR next time. He's going to be back in here on a violation of the protective order.
Oh, but my rulings have teeth, and my ruling was
Absolutely.
there's to be no contact. What has he done on probation other than, get all caught up in his feelings going to somebody's house who doesn't want him anymore? Did he do anger management? Did you do anger management?
I did 5 of the tape so far.
Probation, has he done anything?
Judge, he was granted probation in November. He submitted a negative delay in December. I don't have any indication that any of his classes have been complete. He did pay a total of $190 for his assessed fines and fees.
All right. Is there anything else?
No, Your Honor, and if the court would like to as well, like I said, not a state's file, like me creating a separate thing in a different file chart. I had to draft out the relationships. It's like a whole page of who interacts with who. So if the court, if I could better explain, I would. I have that information. I don't have it with me. It wasn't.
Oh, no problem. The information I have is I ordered that he was not to have contact with Scarlett Jones. He's saying this is the love of his life. This is somebody he's willing to go to prison for, obviously, because he can't let her go. So I ordered no contact. This is an assault family second. He probably would still be in a relationship with her agreeing to be in a relationship with him if this wasn't an assault family second.
Judge, I understand completely where the court's coming from. I think that my client has had some time to, for lack of a better word, get it together. And I think that he can be successful on this. It's his first MTR. I'd ask the court, please, just allow him to complete these conditions. It's zero tolerance. explained it to him, and if he comes back,
All right, the court is finding violation of condition number 19 true. The court is going to find him guilty. There's an affirmative finding of family violence. The court is not going to grant him probation. Would anybody wish to speak to punishment?
Your Honor, I understand the court's ruling. I think that given the facts and circumstances here, and the fact that there's a protective order in place, and my client agreed to that protective order, he has moved on. I think that there is not any imminent danger to Ms. Jones or his family, and I don't see him going by there at all. But we would ask, I know the court's got the full range of punishment. The court's not considering probation. We would ask for a minimum on this, be a minimum of 2 years. This is not something where on this violation, anybody else was hurt. There's no other violence. And we just ask the court to consider the minimum on this case.
State.
And then, Your Honor, the state, in about 10 seconds, Your Honor, the state is accessing the legacy system just to get a better handle on the Bear County criminal history, Your Honor. The state would respectfully request something in the range of about 4 years, Your Honor, and that is the state's recommendation.
All right. Court is going to find you guilty. There's an affirmative finding of family violence. Give you credit for any time served. There's to be no contact with Sydney Jones or Scarlett Jones. Court will sentence you to 4 years in the prison. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and signed it?
Yes, ma'am.
All right, you have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. I want you to know, I listened to the arguments of your counsel. I took that into consideration. And sometimes when the prison sentence that I give people think, oh, she's just doing that because the state requested it. There are different things that I'm thinking of in my mind to see what's an appropriate sentence for you. Do I think you deserve the full 10 years for contacting her when what your counsel has told me there was no violence perpetrated? No. So I wasn't going to send you to 10 years, but I don't think 2 years was appropriate for you either. You understand? All right. Good luck to you. Calling NIMAG number 758930, State of Texas versus Marlon Daniels. Can I have parties announced for the record for the state?
Jason Gary, Hancock.
Defense?
George Sherman on behalf of the defendant.
And are you Marlon Daniels?
Yes,
All right. Defense has filed a motion for release of personal property. State, have you a chance to review that?
I reviewed it last week, yeah.
All right. Any objections?
Yes, Your Honor. At this time, it's just, in just an abundance of caution, the state has not reviewed the possible items that would be returned. I know that there's some identifying papers, and there's other objects that we may not be opposed to necessarily. I believe Mr. Sherman said something about a scooter of some sort for getting around.
Let me go through the list and you just tell me what you have objections to, then I'll hear it. All right. His wallet.
Objection.
All right. And what is the state's objections to him receiving his wallet back?
Identification purposes, Your Honor, for him being in the vehicle.
All right. So is it possible for parties to make a copy of the items that are in the wallet, make a copy of his driver's license, make a copy of the VA documents, have the defendant and defense sign off to the fact that these are copies of the wallet, the driver's license, and the VA documents that were in the vehicle?
I'd be fine with that, Judge,
Yes, that's fine with the state.
All right.
as long as we can do it.
Well, that's something you all have to work out
Okay.
amongst each other. So the wallet, the driver's license, and the VA documents will be returned once the state has made copies of those. Mr. Daniels, can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, ma'am.
You can lower your hand.
Thank you.
So you understand the wallet, the driver's license, and the VA documents will be returned to you once the state is able to make copies of those documents?
Yes, ma'am.
And you understand that your attorney has agreed that you will sign a document stating that the copies the state will make of the wallet, the driver's license, and the VA documents, you will sign a document stating that those documents, the originals, came from the vehicle, whatever part of the vehicle, and that you agree that they will have been found in that specific place.
Yes, ma'am.
All right. Personal documents.
I don't know what the personal documents are.
Badge that you.
What are the personal documents?
Garage door opener, key card for work.
All right, just one second. Let's slow it down.
Right now.
So the garage door opener,
Key card for work.
key card for work,
And there's a gym bag and it has a miscellaneous items in it.
gym bag. Well, here's the thing. We have to be very specific.
Okay.
What's in the gym bag?
Probably pencils, pen, an air pump.
All right, so with regards to the gym bag, the court is not going to agree to release that to you until people have had a chance to view what's in the gym bag.
Okay.
All right? Garage door opener. Any objections? Okay. Key card from work.
Maybe just a copy of the judge. I don't know if it has a photo ID or anything.
All right, so the key card from work.
It doesn't have photo ID, and it's just a regular,
All right, so what we'll do is the state will make a copy. Both defense and you will agree that that is a copy of the original that came from the vehicle. All right, so those will be released. Air pump.
So for basketball or something sort.
What is the air pump?
the air pump was basically for when I have flat tires, emergency purposes.
No objections to that.
Okay. Clothing.
I had two jackets, winter jackets, one hoodie, they're both hoodies, one's a zip up hoodie.
Winter jacket and hoodie. State, is that an item that you all can have somebody take photos of?
That's what I was going to suggest, Your Honor. Just we can take photos of those items.
All right, so they're going to take photos of those items, and again, counsel, and you will stipulate that those items were found in the vehicle?
No problem, man.
Okay.
Sorry.
Documentation from glove box.
I believe it's an owner manual, might be a measuring tape, tire gauge, maybe registration and license, not license, but insurance paperwork. Can't think of anything else that might be in there.
All right, the owner manual.
We'd like that to stay with the vehicle.
All right, so the owner manual is going to stay with the vehicle because really, what can you do with an owner manual if you don't have the vehicle? With regards to the measuring tape,
No objection.
okay. Tire gauge,
No objection.
registration, insurance, and paperwork copies.
We'd like to at least keep that with the court. I'm sorry, with the vehicle, or at least make copies.
All right. So with that, there will be copies. Sir, are you okay?
Just breathing right now, ma'am.
Okay. Do you need to have a seat?
I think I'll be fine.
Oh, just one second. Deputy Laura, we're going to get him a seat.
There he is.
All right, yes, let him have, sir, have a seat.
Thank you.
And just take deep breaths. Do we need to call somebody for you?
No, I should be fine, ma'am. Just hyperventilating.
All right, do you need any water?
Yes, please.
I thought I had a bottle.
Right now, please, on record.
Did somebody see, do we have cups in the back to get him some water? All right, thank you.
Sure.
And then state, do you have any objections to the scooter from the trunk?
Is that this a scooter like
It's
for injured legs?
Yes.
Okay. No objection to that. No.
All right,
Again, I'm sorry, just to take photos of it.
okay.
I believe there might be photos, but I have not reviewed that to make sure.
All right, so this is the court's rulings. With regards to the wallet and the contents of the wallet, this, and the driver's license, the VA documents, the state is going to take photos. Both defense and Mr. Daniels are going to stipulate that those are copies of the original, and you're going to stipulate to the location it was found in the vehicle. The air pump, the state has no objections. 2 jackets, the state will take photographs of those. Mr. Daniels, in defense, you will stipulate that those are items that were found in the vehicle and the location of it. Documentation, the owner manual, that will be denied. Measuring tape, the tire gauge, state if you want to take photos of those and then give them.
Yes, Sean?
The registration insurance paperwork, the state will make copies of those. Both the defense and Mr. Daniels will stipulate that the copies are the originals and to the location where they were found. Scooter from the trunk of the vehicle, state will take photos, and both defense and Mr. Daniel will stipulate that those are photographs of the originals and where they were found. Is there anything else from either side?
Nothing from the state, Your Honor.
No,
Anything else?
Any other items?
if there is, I can't recall now.
All right, so, and counsel, if you all want to make arrangements for you and maybe the investigator or somebody to go view the vehicle, and if there's some items that is not on the list here, you can always come back to the court.
I have it in there.
Okay.
I spoke to him last week, so.
All right, so I'll make notations of this, and then we'll have your client here so he can catch his breath.
Okay.
And they're gonna bring him some water.
All right.
Thank you so much.
Thank you, ma'am.
Sure.
All right,
Thank you, Judge.
you're welcome.
And I'll get a copy of your order
Yes,
for myself.
thank you.
Thank you, ma'am.
Is calling 2021 CR 11076, State of Texas versus Monique Renee Raleigh Williams. Could I have parties announced for the record of the state?
Zach Dunn for the state.
Charles Blunt from Ms. Riley Williams.
And are you Miss Williams?
Yes, ma'am.
All right, can I have a file stamp, please? MTR. Did you review the document entitled Motion to Enter Adjudication of Guilty and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Monique Renee Raleigh Williams who was placed on deferred adjudication in 2021 CR 11076 for the offense of deadly conduct firearm on July 11, 2022 for a period of 10 years? Is that you?
Yes, ma'am.
All right, state.
In Bexar County, Texas, the defendant, Monique Renee Riley Williams, then and there failed to submit to drug testing for the month of March 2024 as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
Your Honor, the state waives and abandons the other conditions.
Any objection?
No, Judge.
Did you understand by pleading true to violation of condition number 2, the court can find it true, grant the motion, find you guilty, sentence you to 10 years in prison?
Yes, ma'am.
Knowing that you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court is going to find violation of condition number 2. True, is there a proposed agreement?
There is a proposal, Your Honor, yes.
And what is that proposed agreement?
The proposed agreement is to follow the recommendation of probation, which is amend conditions for continued CPS compliance, BIP class completion, and a no harmful or injurious contact with the defendant's child's father.
And what's the name of the father?
Jarrell Senquist.
Darrell what?
Jarrell Senquist.
Spell the first name.
Jorel. Senquiz, Senquiz. Yes, miss.
All right, why are you not, you want to raise your right hand for me, please?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, state your name for the record.
Monique Riley Williams.
Why are you not being successful in this probation? You're supposed to report for UH, you're not doing it. Why not?
I missed this one. I'm gonna be completely honest. I had forgotten. I don't do drugs or alcohol. I've never came out dirty. So, I did ask him to, if I can do one that week, and he told me yes. So I did 2 for the next month.
All right, is that correct? Probation that you did 2 for the next month?
Yes.
All right, if you need to get a calendar, you're gonna have to get a calendar. You're looking at 10 years in prison.
Yes, ma'am.
You understand?
Yes, ma'am.
All right. Any other recommendations?
No, Your Honor, that's the entirety of the, proposed recommendations, Your Honor.
All right, I can tell you with regards to Jorel Sinquez, I'm not gonna do a no harm for injurious contact until he provides a letter to probation or comes and tells the court that he wants to have contact with you. There's a reason why people are asking for no harm for injurious contact. So the court is gonna deny the motion, alter the main conditions to include CPS compliance, the BIPP course, and there's to be no contact with Jorel Sinquez. And if there's an issue, obviously there is an issue because it's CPS, so there's a child involved. If there's an issue with child exchange while the CPS case is pending, they can help make that happen without your contacting him. You are not to have contact with him. Do you understand?
Yes, ma'am.
That means no phone calls, no letters, no, I'm sorry, no, let's try to work this out. No, what's happening? Do you understand?
Yes, ma'am.
All right, is there anything else you need from the court?
No, ma'am.
Probation, is there anything else she needs?
No, Your Honor.
All right, we can go off the record. Here's just some side advice that I used to always tell my clients on CPS. When you break up with somebody and you are no longer together, they may tend to bring other partners in your child's life that you think they should not be. What you need to do is contact your attorney, or in your case, contact CPS. But you are not supposed to be putting your 2 cents in that relationship. And whatever you do, if this no contact order is ever lifted and you all are doing child exchanges, don't bring your significant other to the child exchange. And if they bring their significant other to the child exchange, just bite your lip and accept it.
Yes, ma'am.
Because crazy things end up happening when people are bringing girlfriends and boyfriends who really have nothing to do with nothing to a child exchange. Do you understand?
Yes, ma'am.
All right, good luck to you.
Judge, she did want to ask, she's about her diploma. She wanted to ask if that would help with her community service.
Yes, let me see. This is awesome.
College.
And she starts college in August.
Oh, yes, of course that will help. This is great. You know, I am going to Booker T. Washington High School.
Yes, ma'am.
The other schools that had more money than our school had, they did not have the leather binding. And my mom would tell people, hey, where's your leather binding? My daughter has leather binding. But, oh, this is so awesome. I'm very proud of you.
Thank you.
And so what are you going to study? What are you doing in college?
Phlebotomy, hopefully.
Okay, awesome. I can't do that. Don't like the sight of blood, but all right, well, good luck to you. Just keep striving. And sometimes when you're striving to do different things and better yourself, it's difficult. It gets hard, but don't lose sight of what your hopes and dreams are. Just keep pushing it. Even though the days are long, at some point you're going to reach, your degree.
Yeah.
And then you're going to look back on it and you're going to say, that wasn't so bad.
Yeah.
Congratulations.
Thank you so much.
All right. And probation.
Yes,
She's going to go to college. When she goes to college, community service hours will be deemed satisfied.
yes, Your Honor.
All right. Thank you.
Thank you, Judge.
All right. Court is calling 2024 CR 1983, State of Texas versus Ashley Draper Ward. Could I have parties announced for the record for the state, for the defense?
Christopher Simpkins.
And are you Miss Ashley Draper Ward?
Yes, ma'am.
All right. So you entered a plea of guilty. The judge found there was sufficient evidence to find you guilty. According to the plea bargain agreement, the state is recommending community supervision. Have both parties had a chance to review the PSI report, state?
No, Your Honor, but we're okay with proceeding anyway because we are recommending 2 weeks.
All right, defense? All right, any objections to the PSI report?
None, Your Honor.
No, Your Honor.
All right, anything you wish to say on behalf of your client?
Judge, I believe she's motivated, should be successful, and she understands that she faces severe repercussions if she does not live up to her obligations. We ask that you follow the bargaining agreement.
All right, Ms. Ward, do you have any family support?
Yes, ma'am.
All right, who's your support system?
My grandmother's.
All right. And do you have any children?
Three.
Okay, what are their ages?
5, 6, and 8.
And who are they with?
My mother-in-law.
And have you had any CPS cases in regards to them?
No.
When's the last time you had contact with them?
Before I was incarcerated.
So how did it come to be that your mother-in-law had custody of them?
My first incarceration, she took custody while I was incarcerated.
Okay.
Ma'am, can you step up to the microphone?
All right, this is what the court is going to do. Court is going to sentence you to a $500 fine. That's going to be probated. 4 years deferred adjudication and states you may continue to confer. There's going to be 100 hours of community service restitution. I'm going to order you to complete parenting classes.
Yes, ma'am.
There's to be no unsupervised contact with minors.
Yes, ma'am.
There's to be regular reporting by Zoom or in person. I'm sorry, Ms. Eckel, if you could move so probation can, yeah. There's to be regular reporting by Zoom or in person. There's going to be anger management.
Yes, ma'am.
She's going to remain in custody for her Tacoma exam. And they say that's scheduled at August 22nd.
Yes.
And we'll follow those, what their recommendations are. If for some reason she's not accepted, then we're going to do a referral to Center for Healthcare Services. You're going to need to sign a release for any type of medical treatment that you're receiving. You understand?
Yes, ma'am.
There's to be regular UAs, proof of employment, or SSI within 45 days of release. There's to be no employment as a home health care provider or with minors. Field visits, 1 time per month until she receives her case manager. And that's the case manager for mental health. Sorry, just let me check one thing. And also, let's do a referral to felony drug court. And we can also do a referral to mental health court and let mental health court know that if she is accepted to mental health court, the court will entertain a motion for new trial because they'll only accept her if she does not have a open probation case. And the reason why I'm doing that, I think that they will be able to address any issues you have weekly more than this court is able to do. Do you understand?
Yes, ma'am.
All right. State, are you going to have any objections if mental health court were to accept her to for a motion for new trial?
Not at this time.
All right. Probation, is there anything else she needs?
No, Judge.
All right. Is there anything else you need in order to be successful?
Oh, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Don't use your mental health issues as an excuse. Do you understand? I understand mental health, but you were involved in a dangerous situation that could have ended very badly for you. You understand?
Yes, ma'am.
All right. And what's up with all the names? Whose names?
My kids.
Hmm?
My kids.
All right. I always tell people, if you're going to put a name on your body, children, mom is usually a safe bet, not your significant other, okay?
Mhm.
All right. If you need anything, you feel like they're not addressing it, you can always come back to the court, okay?
Yes, ma'am.
All right. What's in your ear?
Earplugs.
I'm sorry. Oh, earplugs. Well, how are you able to hear with earplugs?
They're not very good.
Okay. How does she get earplugs at the jail, or do they make those? Okay, so here's the thing. I know at the jail, people make a lot of things, but all of that is considered contraband, and it'll get you in trouble at the jail, okay?
Okay.
All right, good luck to you. Hello, where's Nick?
He's coming, Judge,
All right.
and he apologizes for his mother.
Oh, don't we're all adults. I appreciate you apologizing for your mother.
I really do.
Yeah, but if she calls you or visits you at the jail, remember to tell her, she can't do that in court. And let me explain to you why. Because we try to run things smoothly. And when people start doing extra in the audience, the deputies are on high alert. They're already on high alert. Then people end up not being able to come back to court. And I know you would like her to be here.
Yes, ma'am.
All right.
I'm sorry. We just buried my brother, so she's kind of.
Your defense attorney explained it to me. So I talked to the defense attorney and the deputy. She's going to be released, but sometimes people need to see how it looks in the back.
Yes.
And then they'll say, okay, I'm going to follow the rules.
Yes, ma'am.
All right. So where are we on this case?
Okay, Judge, I'm recently new to Mr. Contreras' case. He has on his MTR an allegation of a new number one, and for reasons that I can't explain, his new number ones have been pending in another court for a long time.
I can't explain either.
However, I've remedied that. They're going to be transferred to this court. Mr. Garahan, for that reason, has never even seen the new number ones.
Okay.
So so we're going to ask for some time
Okay.
for that to happen. In addition, no one's ever asked for a bond to be set on Mr. Contreras' MTR. He's on deferred adjudication for this offense. I'm asking the court if we consider setting him a bond.
All right. Let's do first things first.
So I'd like to reset his case first.
Yes. All right. So, yes, I don't know why those cases are.
But that has been fixed. I've spoken to your court staff and they've remedied that as well. So.
All right. So, Ms. Ferguson, let's recall this in 30 days. We'll call it in 30 days as far as the discovery. It won't be set for hearing yet. So, all right. So it's going to be July 25th.
I'm out of town. Can we do the following week? Yes.
Sure.
Please. Yes, that's perfect.
All right. So August 1st for discovery on new cases.
Attorney, are you Mr. Bunk?
I am Charles Funk. Yes, ma'am.
Thank you.
All right. And state, are you prepared to proceed on an oral motion?
Yes.
All right. Court is calling 2021 CR 2910W State of Texas versus Rick Anthony Contreras. Route parties announced for the record for the state. Defense.
Charles Bunk for Mr. Contreras.
And are you Mr. Contreras?
Yes, ma'am.
All right. Defense is asking for bond and by way of oral motion. Any objection to the motion being oral?
Not from the state, no, Your Honor.
All right. The defendant is on deferred adjudication. Legally, he's entitled to a bond. Have you all had a chance to discuss a bond amount?
No, Your Honor.
Do y'all want to discuss a bond amount?
Who's that brings the judges? That we've agreed, if it satisfies the court, we're in agreement at the bond being set at $10,000.
All right.
That is correct, yeah.
All right. The court, the defendant is on bond out of this court, so the court is aware of the defendant's criminal history. The court is aware of the defendant's mental history, which does not exist. And so I'm just putting on the record that the court is aware of his background. So Since you've been at the Bear County Jail, have there been any mental health issues that have arisen?
No, ma'am.
All right, are you on any type of medications?
Not ma'am.
All right. And do you have a place to live if you were released?
Yes, ma'am.
And are there only adults in the household?
My son lives there.
All right, how old is your son?
He's 3. He's gonna be 4 in October.
All right, so your son is there, and who else is there?
His mother.
Okay. All right, this is what the court is going to do. The court is going to follow your agreement. Set your bond at $10,000. There should be no unsupervised contact with minors, so you can have contact with your son, but there needs to be an adult there.
Yes, ma'am.
And there's going to be, you're going to have to do UAs. Probation will tell you of a location you can go. Since this is still pending
Yes, ma'am.
and open, the motion to revoke, you're not currently supervised by probation because the motion to revoke is pending. So they'll let you know where you can go to do UAs. It just won't be done under them. Do you understand?
Yes, ma'am.
So I'm going to order regular UAs. Is there anything else?
Nothing else, Judge.
All right, thank you.
Thank you, ma'am.
May we
You're
have a great day.
Yes.
Thank you.
You're welcome. Court is calling 2024 CR 4842, State of Texas versus Clarence McDaniel. Can I have parties announced for the record for the state?
Andrew Harris Edelman.
Defense?
Marissa Giovenco, it's Giovenco for Mr. McDaniel.
All right, and are you Clarence McDaniel?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. McDaniel, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Proceeding on count 1, waiving count 2, Your Honor.
Any objection?
No, Judge.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
You're gonna need to keep your voice up.
Yes, ma'am.
Did you understand that the state is proceeding on count 1, that's possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams? That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge, I do.
Mr. McDaniel, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is proceeding on count 1. Punishment is to be assessed at a cap of 6 years in the prison. There's a $2,000 fine. This will run concurrent with County Court 14 number 726688. State is taking in consideration 726689, 726690, 2024 CR 4841. There's to be restitution in cause numbers 726689, 726690, and the state is silent on your applications. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea.
Judge, just to be clear, my understanding was it was going to be a cap of 7. We are happily going to accept a cap of 6 if the paperwork says otherwise.
No, the paperwork says the cap is 7.
Okay, you said 6 on the record,
Oh,
but I
I'm
wanted
so
to be
sorry. I thought
clear.
I said 7.
Okay,
All right, so is that the plea?
yes, Judge.
State, is that the plea?
Yes, Your Honor.
All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the state. By the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Then to the offense as charged in count 1, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State, any evidence?
Contained in Exhibit 1 and attachments, Your Honor.
All right, state, you may be excused.
Obliged, Your Honor.
I have reviewed that with my client. We have no objections.
All right, Mr. McDaniel, did you understand again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Probation, is there any way to expedite this, or is that too much expediting in the court?
It's early try for you, Judge.
All right, Norma, could you put this, if we were to put this at the end of July, you think, just to see if we were able to do it?
Yes, sir.
All right, Norma, could you put this as for sentencing the last week of July? All right, we'll bring you back on July 29th. Counsel, of course, if it's not prepared, then we won't proceed. We'll get a new date.
Okay, thank you, Judge.
All right, thank you.
Understand why people don't understand when people don't want to. And that is where the hammer drops. The judge completely shuts down the excuses and reminds everyone that a court order is not a suggestion. You cannot cause damage in a relationship and then act shocked when the other person moves on and the law steps in. Justice does not always move fast, but when a judge loses patience, reality hits hard. Let me know in the comments if you think the judge handled this perfectly.